Good morning, good afternoon, good evening, wherever you may be. Thank you for joining us for today's event, which is jointly offered by Delos Dispute Resolution, the Institute of Arbitration of the Stockholm Chamber of Commerce, and the Vienna International Arbitration Center. And we've got a great panel of speakers with us today, whom I'll introduce shortly. But maybe just to start with where this event has come from, if arbitration had a dictionary, then remote hearings would certainly have been a strong contender for arbitration the term of the year in 2020. And so we thought it was helpful to step back from that. Now, as some of you know, with Gary Bourne and Annelise Day, we ran a survey of users' experience of remote hearings in June, July 2020 with the help of Delos. And I'm going to show you something, but obviously screen share is always a bit complicated. While we're talking, you can have an eye on this. And we were very grateful to have the support of a number of institutions, in particular today, the SCC and VIAC. Now, what the figure on screen should give you an insight into is the size of the phenomenon of remote hearings last year. Everything happened very fast. As you can see, there was a massive spike in a blurry, challenging, changing environment. And I've got a moment's doubt as to whether my screen share actually worked. Obviously, no, never mind. Okay.
It works now.
Okay, thank you. So you can see there was a massive spike. Now, the environment was very blurry and disruption working from home were bylines for our day-to-day. And there's a certain amount of information that we're able to process rapidly, and that's the fast in our title. And then there is information that takes more time to ponder and consider, and that is the slow in our title. Now, the title is a reference to Daniel Kahneman's seminal book, Thinking Fast and Slow. And in the course of our discussion, we will highlight additional dimensions of the fast and slow of 2020 and what to make out of those as we're looking forward to 2021. Before we go any further, I'd like to say a few words about our panelists. None of them require an introduction, but if you allow me in a few words, we have Dr. Alice Fremuth-Wolf, who has been Deputy Secretary General of VIAC since January 2012. She lectures at the law faculty of Vienna University, and fun fact, I'm told that she can be spotted around town during the Vismut, usually at the most exciting places. Next, I've got Ndanga Kamau, who's a well-known arbitrator and counsel based out of The Hague with an international practice. Her fun fact is you will never guess how many cities she's lived in: Cape Town, Geneva, Houston, London, Mauritius, and Nairobi. We have Annette Magnusson as well, who's been the Secretary General of the Arbitration Institute of the Stockholm Chamber of Commerce since 2010. Here, I'd like to highlight the fact that besides practicing arbitration, she's also produced a documentary, albeit one on arbitration, which is known as The Quiet Triumph. And last but not least, Professor Max Yishera. She's a special counsel at WilmerHale, regularly sits as arbitrator. She holds the chair for international arbitration, dispute resolution, and energy law at Queen Mary University of London. She serves on the Delos Board of Advisors and acts as general editor of the Kluwer Journal of International Arbitration. And my fun fact for her is that I never quite know where she is located. So she's an international woman of mystery. For my part, I am the head of Delos Dispute Resolution, as well as an independent arbitrator. Now, without further ado, we're going to dive into our discussions, and the format is going to be quite conversational, and we'll start with the following. In May 2020, so for some of us it will feel like a lifetime ago, but it was less than a year ago, Max Yishera, you defined the concept of a remote hearing, and you even managed to quote Voltaire in doing so. What key questions would you say we were grappling with at the time as a community, and how has the discourse around remote hearings been evolving since?
Thank you, Hafez. Thank you for the invitation to this webinar together with the SEC and VIAC in putting this together. It is a very timely seminar. As you said, we've been thrown into this remote hearing mix in 2020, and I think it's a good thing now to reflect and to think about what we've done well and what we could do better. I was just worried about what fun fact you would release for me, so I'm not going to tell you where I am now, but I'm going to try to answer your question. So the discourse, of course, with remote hearings has changed tremendously since the beginning of the pandemic, and the article you mentioned, I did actually write very much at the beginning of the pandemic. On the basis that I had already some experience at the start of the pandemic with remote hearings. Indeed, remote hearings are nothing new. We tend to forget that. I had my first remote hearing some 10 or so years ago with witnesses being located in other jurisdictions. It wasn't a fully remote hearing. The arbitral tribunal and some of the participants were together in London, but a number of participants connected remotely from different jurisdictions. If you look at exit statistics, for instance, even pre-pandemic, the majority of their hearings and meetings involved some video conferencing. So it is important to remind ourselves that it is nothing new. But what has changed, of course, and this is where it's a fundamental landslide shift, whatever you want to call it, is that it has become the norm. It has become really mainstream, and it has become, in most instances, actually the only way to conduct a hearing. So the balance is not between a remote hearing or an in-person physical hearing, but it is sometimes, at least it was at the height of the pandemic, first wave, and unfortunately now again, second wave, depending on the jurisdiction where you are, it is between holding a hearing and holding no hearing at all, holding a remote hearing and holding no hearing at all, having to suspend that. And there is some very interesting data in the survey, Delos survey that Hafez mentioned as well. So that, of course, is a very important paradigm shift. The other thing really is that people have become more accustomed with remote hearings. A larger number of people have become accustomed with remote hearings, and we've all done more, obviously, in 2020 than any time before. And that is important, I submit, not only because we get better at it, but also because our perception about remote hearing changes. There's a very interesting survey, which I cited in my article as well, which was done in 2006 already, so well before anyone would think about COVID, obviously, in the US with judges. And the question was put to them, how do you feel about video hearings? Do you feel it's the same in terms of how you interact, how many questions you can ask, etc.? And there was a really interesting takeaway from that survey, and that is the more a judge was accustomed and experienced with those video hearings, the less disadvantages he or she would see. And I think that's a very important point. And I also see this anecdotally, at least in my interactions with people throughout 2020, is the more they used virtual hearings, remote hearings, the less they thought about disadvantages, or at least about some disadvantages. It's not to say that there aren't any disadvantages, and we will have the chance, I suppose, to discuss some of them over the seminar, but quite a few that initially people thought about didn't necessarily materialize. Maybe one last remark, just because you mentioned it, is on terminology. The reason why I personally prefer the word remote hearing or video hearing over virtual hearing is that virtual hearings, in my view, is actually a misnomer. Virtual is something that does not exist. If you, for instance, think about a video game, a virtual reality is a reality that does not exist. That is only a fiction. The hearing, however, even if it is done by video conferencing or any other means of telecommunication, so futuristic it may be, is still very much a real hearing. It is still an exchange of arguments and evidence taking. So the term virtual, in my sense, is for a hearing is not the correct term. One could consider speaking about a virtual hearing room, and now some of the Zoom versions not only put you together like little pictures on the screen, but actually put you in a room as if you were sitting there in a virtual hearing room. And that virtual hearing room is indeed virtual in the sense that it does not exist. The hearing itself, however, very much exists, and therefore I think it is important to call it properly not virtual. You can call it whatever you want, video, remote, you choose your weapon. So with that, I'll stop, and I'm sure my excellent co-panelists will have comments on all of that.
Annette, would you like to go ahead?
Thank you, Hafez, and hello, everyone. I thought I would share a fun fact about you, Hafez, as we begin, since I just learned at the beginning of this webinar that you actually speak a bit of Swahili. I think that was a fun fact. So, but anyway, hello everyone, and thank you for being here with us today, and thank you, Maxi, for the introduction. I just by means of jumping into the topic and jumping into sort of looking back at last year, I think one observation that relates to the use of remote hearings and sort of all the other technical tools is that one could really say that international arbitration had to deliver on its promise. We talk about, and we have been talking about international arbitration forever, rightfully so, as being efficient, as being governed by party autonomy, as being flexible. But I don't think we have ever been at a challenge really putting those statements to a test as we were last year. And I do think that the way the entire community globally jointly managed to push through and find ways through this maze really demonstrates that we were able to deliver on those promises. And I do think that once the dust has settled after all this, we should really be proud of the way we have done here, and also of all the individuals involved who have been very open to taking on new technologies and to using the new tools. And I do think it is also important to find the time to reflect. We needed to solve the acute crisis then and there, and we have done so. And so it's good that we can also sit down and think about what we did and then see how we can plan for the future. But again, I think for me personally, as heading of an arbitral institution, and I'm sure Alice will agree with me, that it gives us great pride to see that the entire community were able to sort of step up to the plate and really take on this challenge and use these tools that have been around for such a long time and seemed like an abstract, and now you needed them to really do your case and manage your proceedings going forward. And I must say, I have been very, very impressed with what I have seen.
Maybe I can jump in directly here. Hello, everyone, also from myself, from Vienna. And I absolutely have to agree with Annette. I was amazed how this arbitration communities stick together, especially the arbitration institution, which naturally are usually competitors. And, you know, everyone tries to have a new feature and this and that. All of a sudden, we really had one common goal. How can we make this work? We were discussing amongst ourselves various problems, how to tackle this and the other issue. We were coming up with ideas, even offering vice versa the use of facilities, and developing even this joint statement that we were issuing to really give certainty to the people out there that we are here. We are trying to make your arbitration work no matter what institution you're in, or even for ad hoc arbitrations, we offered help. So I think in that we really put sort of the things that were out there in terms of remote hearings on a safe standing, and also all the decisions that have been rendered now. I think they are largely based also on articles that, for example, Maxi has written, and the books and all this legal information to reinsure also judges that had to were confronted with it, to give some guidelines and let people know this is not a new animal. It's just being, dug out, and all of a sudden we have to deal with a lot of questions that we have never thought before. But there is a way, and this is not something that is strange or unusual. We just need to put it into relation and find certain guidelines. And I think in that also the institutions were great. There are a lot of guidelines and also protocols out there, and I think each one of them is valuable because it puts a different light on a different angle, and the one is sort of focusing on technology, the other one is a checklist, and so there's really a great variety of sources available for arbitrators, for parties, for users, where they can really dig from, and it's available free. I mean, we just sort of prepared it and offered it to the market. And that was for me a great moment, actually, despite all the bad things that happened last year.
So actually, if we're going to talk about some of the victories of last year, there was one in July 2020 where the Austrian Supreme Court handed down a decision about whether you could hold an arbitration hearing by video conference over the objection of a party that was alleging a violation of due process. And Alice, actually, if you don't mind continuing then, what are the key lessons we should draw from that decision, and what issues would you say remain open?
Well, yeah, first of all, thanks to Maxi and her team, this decision was being translated and published, so it's available basically to everyone. And I think it really set a landmark for future decisions to come. And I think in what it was so welcome is that it set certain things right that we all basically knew, but there were still some fears. Could an arbitral tribunal do it against the wish of one of the parties? Would that be against the fair trial, and so on? So there were a lot of question marks out there. And I think for once, the Supreme Court really tackled those issues and did not shy away from avoiding them, but directly addressed them. And I think it's also interesting to note that it was a decision in a challenge against the arbitral tribunal. So it was not a setting aside against the award, but a challenge against the tribunal that had been accused that the mere fact that they ordered a hearing against the will of a parties made them impartial and independent. And I think for me, there are sort of 6 takeaways from that decision that will sort of lead the future discussion. First of all, it made it pretty clear that the mere ordering or holding of a hearing against the will of one of the parties per se is not sufficient to trigger any kind of right to be heard concerns, or in itself is not a proof that the tribunal is impartial or independent. And probably, with ... this will also be the case in a setting aside of an award. So this alone is not sufficient. So it put on hold to sort of all sorts of recalcitrant parties who are just trying to obstruct proceedings, threaten the tribunal and say, if you do order this against my will, we will, have you challenged, and by that trying to avoid the proceedings to go forward. Actually, the Supreme Court really stressed that in a pandemic situation, and I think that's also the specificities here, in a pandemic situation, it's basically the only means to go forward if we do not want to have a standstill, and even state courts have employed that. So he was very explicit to say there's no Article 6 of the Human Rights Convention violation, and so on. It also said, and here we're touching a bit on this sort of burden of proof issue, if the tribunal is to order a hearing against the will of one of the parties, how should it go about it? And it had the stance that sort of in a situation like the pandemic, where you really have no other option, instead of halting the proceedings forever, it would be the party who resists the virtual hearings to actually sort of prove, or at least show why in that particular circumstances it would not be fair, or it would be at its disadvantage. So really as I said before, it's not sufficient to say the virtual hearing per se is the problem, but you have to sort of list and indicate why in that particular case it could be a problem. And of course, and I think also the Supreme Court made that quite clear, it's not a free rider. I mean, the decision should not be seen as a free rider that you can from now on order virtual hearing against the will of a party and just, you know, go by and nothing will happen, but it has to be made an assessment. And there are particular issues, and he listed two. For example, time zones and the witness tampering, that can be an issue, and the arbitral tribunal has to be cautious of that. In this case, one of the parties was located in Los Angeles, and the hearing time was set at the time when it was 3 o'clock here in Vienna and 6 a.m. in the morning. And the Supreme Court also assessed it and said it's an unusual time, but in international arbitration, we are all used to, you know, fly around, facing jet lags and so on. So even if 6 a.m. seems a bit unnatural, the question is, would it be less burdensome to fly in from LA to Vienna and then, you know, with a big jet lag attend an in-person hearing? So here, I think being mindful, the tribunal really has to be very careful of not placing one party always at a disadvantage. So if you have a hearing that lasts for like a week, you have to take shifts. And if you have people from different time zones, make sure that once it's the one party that has to get up early or stay up late and not always the same. Because if you do that, that might again create an issue. But still not per se the time zone issue is sufficient. With respect to the witness tampering, the Supreme Court also said just the mere fear that there might be witness tampering again is not sufficient for a virtual hearing to be unfair, but you have to show concrete cause. And of course, witness tampering is always an issue also in in-person hearings. And it's up for the tribunal, if that was brought up before, that it has to put in place certain measures, for example, to put someone in the room, to have a 360-degree camera, to ask the witness to put the hands up in the air, etc., etc. So it recognized that this is not something that doesn't exist, closed its eyes, but said you can address this, you can take care of it. And I think the last and most important takeaway is, and that decision sort of by the tribunal to hold the hearing was rendered at the time when really the pandemic had just hit. So they had not thought about it before, but now we are sort of beyond that, is careful planning. And I think that's the biggest takeaway from this decision is it's for the tribunal at the very outset, together with the parties, to really go through all these issues and make sure to find an agreement in past cases or an assessment and reason your decision why you decided for this or for that and why you think that that is fine. And then your award should be safe and also the tribunal should be on the safe side. That would be my takeaways, but maybe Maxi has something to add since she also analyzed this decision very carefully.
Well, I should first of all thank Alice for actually drawing my attention to this decision. I'm going to post in a second the link to the Kluwer blog that we wrote in the Q&A, so that if you want to, you can access it. And I would actually recommend that you read the Supreme Court decision. It is actually really well written, and it is the first Supreme Court decision at that Supreme Court level, as far as I'm aware, who really deals with these issues. I have nothing to add to the legal analysis that Alice presented, but I actually have a fun fact about the decision while we're speaking about fun facts. The challenge of the arbitral tribunal was on the basis of the remote hearing. But one arbitrator was actually also challenged because he allegedly rolled his eyes when the party made some objections to the remote hearing. So the reason I say this is a fun fact is, well, of course, first of all, the challenge was rejected, but I think it does show quite nicely how close you are in a remote hearing. You would have probably never seen an arbitrator roll his or her eyes in a personal hearing, or maybe you would have sort of guessed something. And second, you would have probably not have a really good evidence. Here you have a recording of the hearing, and so you can see it, you can rewatch it, you can analyze very clearly, has she now rolled her eyes or has she not? The reason I say this so importantly is one of the points that a lot of people say is the other way around. Do we actually see witnesses well enough in remote hearings? Is there not a sort of a distance between the hearing, the tribunal, counsel, and any witness? And my experience, at least on the tribunal side, is I've never been closer to witnesses because I see them on a big screen in front of me, and I do see every twist of their eyes or every twinkle, and if they roll their eyes. And I think this is the point, even though not that point, but the point is very well made with the reference to the Supreme Court decision.
I'm wondering whether, so I'm aware that there are further proceedings on the topic of challenges arising from remote hearings, but I don't put anyone on the spot. So if any of you would like to discuss them, then feel welcome. Otherwise, I'd like to look at another angle of this question, and I'll turn to Ndanga, which is part of what Alice was highlighting was the need for thorough anticipation of issues, and either the tribunal on its own or with the parties. And so I was wondering, in your practice as an arbitrator, what would you say are the problems and opportunities that can arise for you from remote hearings? And I know Maxi's touched upon them already to some extent.
Thank you very much, Hafez, and thanks to you, the SEC and VIAC, for having me in such distinguished company. So I approach this question from the perspective of sustainability. So I'm querying, perhaps being devil's advocate a little bit, querying the sustainability of the status quo and this uptake of remote hearings. So we've already heard from the speakers that came before that the status quo has been forged in a context of emergency. So that's the first. So we see that the community reacted very quickly, but was reacting very quickly in a context where flights were grounded, borders were closed. And as Maxi said, it wasn't an option of do we have remote or not, it was do we have a hearing or not. So we see then this outpouring of checklists and guidelines and on all of this, protocols arising out of that fast, out of that need to really react quickly and build a framework so that the bus can continue along its route. Now, we've also seen some problems arising out of this in that we're rushing to keep the bus moving without really making sure that the tire pressure is correct and all of that. We just want to keep the bus along this route. Now, if we're going to get to the slow, we need to pause and ask ourselves some questions. And some of those questions are not that easy to answer. So some of the questions that we have to ask ourselves are, do we really want to be recreating the physical live hearings in a remote context, which appears to be what we're doing, when we're not actually truly reflecting on how remote hearings should be happening? At least I haven't seen much reflection on that. We're simply saying, okay, we can't have the physical hearing, we can't be in the same place. Let's recreate what we're already doing in a physical context in this remote context and keep the bus moving. And that spirit, that community spirit and all of that, we see also in the acceptance of these hearings across multiple time zones. So we're seeing that people are prepared or have been prepared thus far, at least until where we are in 2021, to accept the discomfort, to accept the inconvenience of these early starts and late finishes, simply because we want to keep the bus moving. Now, that's all very well for now, because we're still in a pandemic situation, we're still in an emergency situation, and we still need to keep these hearings going. But if we're really to go forward, and if we're really going to use this opportunity to transform how we use this which I think is a fantastic facility. I think the ability to have remote hearings in the way that we've been having them and in the way that we could have them, I think is a fantastic facility, which our community has not taken advantage of to its full extent. And this pandemic has allowed us to see the possibilities, but we're still in the fast, and we're still thinking in fast. We're not yet allowing ourselves to think in slow, and we're seeing, the vaccine is coming, some borders are opening up. At some point, we have to take our foot off the pedal and stop the bus. And the question is, what's going to remain? Are we truly prepared to really sit down, bring all these protocols and checklists and guidelines together and say, okay, what out of all of this is actually useful? What's good? What should we continue? What can we improve? Should we be standardizing across rules and jurisdictions? Should we be building more bespoke systems? What part of the remote hearing stays, what doesn't? Because the risk is also that once everything opens up, then we return to status quo. So we say, okay, we've missed each other. It will be great to see each other. Let's convene in Paris. Let's convene in Singapore, and then we forget all the lessons that we've learned. So my question, just going back to the start of my remarks, is really about sustainability. We're celebrating remote hearings, but we haven't yet addressed the sustainability question. And just a note on terminology. I think, Maxi, the fact that you highlight this distinction between remote and virtual, I think really goes to this point that we were just so quick to jump and to adopt a new way of doing things that we never stopped to ask ourselves whether the terms we were using were actually accurate. And when we eventually take our foot off the pedal, I think that's a good time to also think about the language we use and the mechanisms that we use. So I'll stop there and let my colleagues share their thoughts on my remarks.
I'm happy to jump in and just say that I couldn't agree more with Ndanga that we really need to think on how we reproduce hearings in a remote space rather than just doing what we've always done before. And I think it's a wonderful opportunity to actually reshape find a new architecture for the arbitral process as a whole. Now, I cannot tell you what the future brings, but I can already tell you a couple of things that I certainly have seen or I've explored in some of the proceedings I've been involved in, rather than doing the sort of plain vanilla standardized procedure that we always have, 2 rounds of written submissions, an evidentiary hearing, maybe some post-hearing briefs, whatever. There are a couple of things that we can do using the opportunity of remote hearings. The first is we can think of a number of mini hearings throughout the proceedings. Because it's now easier, it is easier in a remote setting to get together. That certainly helps convincing the parties that there might be an issue that one would want to resolve up front, for instance. I've also seen a discussion about the actual hearing itself, whether we do need to have a week or 10 days or 3 days or however long it takes together in one row. Instead, one could actually consider, for instance, to have opening statements up front and separately, so that the arbitral tribunal can have the opening hearings with the parties, but then reflect a little bit before going into the evidentiary hearing, potentially ask a number of specific questions before going into the evidentiary hearing. Conversely, do we really need to have the closing submissions the day after the evidence taking has finished? It inevitably leads to late nights for counsel. So why not have a couple of days of pause? And I've certainly had that in a number of my remote hearings, and I found it very good. I've not been on the counsel side. I hope counsel found it more relaxing, being able to at least sleep a couple hours. But also on the tribunal side, to be able to reflect, to go back to the transcript, to read certain things that have just happened during the evidentiary hearing, potentially discuss certain points amongst the tribunal, obviously not a deliberation, but sort of a pre-discussion, so as to be able to ask specific questions during the closing remarks. So all of these are little bit new ways of thinking about the arbitral process as a whole that were possible because a hearing is remote and because we're not together in one place and we all have to leave our hotel rooms and the conference room where the hearing is at a certain hour.
If I can just jump in, I think, Ndanga, you're really touching upon something that is truly important. And I think it's important not only for international arbitration, but I think for any area of work these days. So we have all these virtual opportunities where we move our physical practice or routines into the virtual environment. What do we just sort of take the physical into the virtual and do the same thing? Or do we actually use this opportunity to do things very differently, the entire process differently? I think there's there could go a lot of thinking into that, and there are experts out there that are much better than me in doing that. But I think it's really something we need to think of. So we not only just repeat what we have been doing, but in a virtual context and not changing. And Maxi, I think you had some really interesting thoughts on there that you sort of how you can tweak. But one could even think that using technology at large for the benefit of what we're here to do, and that is to decide disputes, right? So if you want to take a philosophical view on it, so what is a dispute? Well, it's actually two sides that have different views on something that happened in the past, and they need to find somehow to ending up in a place where someone decides how that that element in the past should be defined, and whether or not property or something else should be transferred between the both sides, and someone should decide that, or some other sort of uncertainty needs to be decided at the end of this process. What happens in between there, we for us sitting in this webinar, we use international arbitration, but one could imagine that something different happens where technology could step in, and we will maybe come to that at the end of this webinar. Technology could step in and offer opportunities and do things differently. That could be a bit scary potentially, but also I think and disruptive. But I think we should not shy away from having that conversation. That given now that we have taken this one step on this journey on the virtual or digital road, so to speak, what lies further down the road? Because we can be sure of one thing: if we as specialists in the arbitration community do not address that issue and do not think of it, there are plenty of others out there that will, and they will step into that space. So I think we all need to be part of that conversation to make sure that whatever happens between the beginning of the dispute and at the end, not only is smart and effective from a technical standpoint, but also defends values like rule of law, equal treatment of the parties, and what have you. So I think that's something we need to keep in mind and chip into that conversation.
I would just like to add a very different angle, because to that conversation, and I agree to everything. And I think we have been so sort of focused now on the issue of remote hearings and the technology and how we can tackle that, that we sort of, we also need to think a step further. And I'm thinking of, rendering the award issue. Now we are all used to this technological, remote hearings and all the facilities, but we're still, when it comes to the rendering of award, we are back to the analog world, because for purposes of enforcement, of setting aside, all the courts require this hard copy, personal signed sort of copies, and we have failed as a community so far to have a convention that really allows us to electronically sign jointly documents that are then recognized, because it's so illogical that you have all these great platforms out there. You can do everything online or virtual or I mean remote, submitting documents, but when it comes to the rendering of a word, we still need paper. And I think that is a real issue that as a next step for me needs to be tackled. And it's a shame that this is still sort of unresolved.
And to your point, at least as a first step with Maxi, I think Maxi also wanted to comment on this. We've got a project ongoing where I think by the summer we'll have a review of some 60 jurisdictions in terms of where they stand on digital signatures, on blockchain, arbitration awards on blockchain and so on, which can then help take the conversation to the next level, because then you've got information to base yourself on. But I think Maxi, you wanted to say something.
I wanted to say exactly the same thing, and this is Hafez's gap, obviously, that I have the pleasure of co-chairing, but I could not agree more that one of my most frustrating experience during the lockdown was that we had all these remote hearings, but then I had to actually take a car, physically go to an arbitrator's house to have the award physically signed. It was just crazy. And then some people, were in remote country houses and try to, find someone who get the paper to them. It's crazy. It's absolutely, it feels like from a different century. And if you think about it, what is it? It's a piece of paper on which you put a wet ink signature that can be forged much more easily than any electronic signature that even public notaries in France now accept electronic signatures for buying a house, which is certainly more important than one could argue, than an arbitral award. Anyway, so I could get really hung up on this one, but there are of course some. The SCA has revised its rules recently to include electronic signatures as a possibility. So I think it is the next step, next logical step. One thing I wanted to add, and just sort of reflecting again on what Ndanga has told us to do, is to sort of think about how the process will change, the sort of slow thinking. I would be very interested to see, looking back into 2020, whether there are more settlement of awards, settlement of disputes in case of remote hearings, not because of the pandemic, but because of remote hearings. Because at least it is my anecdotal experience that the party's representatives seem to be present more often in remote hearings than there are in physical in-person hearings. And I suppose that is because they can pop in and out from their office. They can, maybe deal with other work on the side. So have a general counsel or anyone from the party there is easier and obviously less costly than if it was a physical and in-person hearing. And often, in my experience, that then leads potentially to settlement discussions offline. I don't know if that is the case. It's just a thought, and certainly something that empirically needs to be tested. So one of the slow reflections that one could do, thinking back on 2020.
Well, actually, to that point, what we did observe as of June, July last year is that of all the hearings that were reported, 4% of them did not actually proceed to a hearing because of the pandemic and settled instead. That's very anecdotal, and to your point, I think we would need a lot more data. Besides our survey, there was also another survey run in October of last year by the SCC. And Annette, I was wondering whether you might want to say a few words about it.
Sure. So I think, again, going back to sort of the common experience that we all share, I think the SCC survey from October and the survey referred to earlier, we share many similar conclusions in the sense that the use, obviously, of the virtual hearings spiked as a consequence of the pandemic. I mean, that's no surprise. Just to give you a little bit brief background, this was a survey we did in October, and we looked at all the cases pending or that were initiated after 15th of March. That's sort of the deadline we chose. And looking at the cases that had come as far as holding a hearing by October, 1/3 of their cases where there had been a hearing, they have turned to virtual hearings. So obviously much higher than you had seen before 15th of March. But in a number of the domestic cases, the tribunals and the parties were able to hold physical hearings, taking into the precautions of the pandemic and so forth. But it was interesting to see the great support of the use of virtual hearings also in this survey. But again, also there are some things to take into account in terms of what are the challenges and what are the things you need to take into account if you are organizing a virtual hearing. One of the quotes from the survey is like, keep your IT person close. I think that's probably very good advice. And also, even though it's wonderful that you are able to hold the virtual hearings, there is also this sense that it is a consequence of the state of emergency, so to speak, that many of the respondees would still prefer to be able to meet physically. They see that the advantages of the actual physical hearing. You could still sort of sense that from the arbitrators that have responded. And I should say that the respondents here were chairpersons or sole arbitrators in the SSC cases during this period. So the advantages, then, you will not be surprised that the time issue obviously being a large advantage. Otherwise, given that it was and still is so uncertain when we will be able to meet physically again and travel, in the end, postponing the entire proceedings until that time simply has not been an option, right? So you can safeguard the efficiency of the procedure and have your reward rendered in a timely manner. Obviously, no travel costs, so the cost advantage is also highlighted. And the convenience that entails of not having to travel. And also a fair number of respondents also mentioned the less impact on the climate with less emissions given less air travel. So I think that's an interesting observation as well that we're seeing in the survey. Now, again, when it comes to disadvantages, there we see again this, which Maxi alluded to before, that sort of the sense of it's been said that you miss the human touch, right? But I do agree that to some extent you get a more human touch because you get closer up front. And I think when we had one of the first seminars at the SSC about online hearings before summer last year, I think there was a comment about, well, I can't see the witness persons, or I can't, I don't get a proper view. And someone just said, well, get a bigger screen, right? So that's doable. You can address that. But again, that's something that is felt by the arbitrators involved. The loss of human touch is seen as a disadvantage, and of course having the technical challenges. And I think we will come back to that later in the discussion when it comes to sort of, are we on an equal playing field when it comes to the technical opportunities offered? Because let's not forget that we are all not based in equally connected spots in the world, or equally equipped spots in the world when it comes to technical tools. So that's something that really needs to be kept in mind. One thing that I do find interesting when it comes to sort of the results of the survey is that, and I would be interesting to hear the arbitrator's view on this, the Ndanga and Maxi, is sort of the advocacy skills that you require or that you use when you are in the virtual hearing setting. So which will obviously differ when you are in a physical room. And that's something I think is quite interesting, because we, just as the human touch is perceived differently, what is the body language and how do you present yourself and how do you argue your case, how that could differ if you are in a virtual hearing setting as opposed to the physical. So I think that's something that probably, as we looking forward and continue using the virtual option, I think that in and by itself probably will be something that we will have to discuss and address more and potentially develop our skills. But I will be interesting to hear Maxi and Ndanga's views on this.
What I might suggest is let's wrap that up as part of the later discussion. I'm just aware that we've got a lot of topics that we wanted to cover, but I'd like to come back to that. And what I'm going to do is, while we're talking, I'm going to show some more statistics. These are a preview of some of our further findings from the survey, which also go to benefits or perceived advantages and disadvantages of the process. And while you're looking at that, my next question is going to be for Alice. The question I was going to ask you actually was about June 2020, the protocol published by the VIAC on remote hearings. And maybe on the slow spectrum, it was one of the last such guidance documents to be issued, but it was very welcome. And so what I'd like to hear from you about is, what was the impetus behind preparing a protocol? How do you look on it today, especially in light of some of the comments that have been made in today's discussion? And if you allow me, I'm going to wrap in to this some of the questions that are being sent to us via the Q&A, to the extent they're relevant to how you look on the protocol today and everything that was said about the guidance that's available and so on. One of the questions says, asks about the most common objections a party can raise to oppose remote hearings, and presumably how should those be dealt with. And another asks about, should there be amended procedural safeguards in place to accommodate the specific technological challenge posed to the procedure? Or do you think that what's there already is sufficient to address the online environment and its challenges?
Okay. Yes. Well, first to the VIAC protocol and why we decided to publish one when there was already a lot of information out there. I think we thought it was important also given the market that we serve. You know, being the Central and Eastern Europe and Russia and all that market, we have not seen a lot of guidelines or protocols from institutions from that region, and we are still seen as one of the sort of benchmarks there. And we also wanted to give safeguard or a checklist to arbitrators, not only under our arbitrations but also for that particular region, to say what are the best practices. And asking, if I look at the protocol now, of course there are a lot of issues that now we say, okay, that's so clear, of course you have to do that, of course you have to do that, you need to have this and that, and you have to look at the legal surroundings. But at that time, we still felt that in a particular region, maybe these things that we consider obvious were not that obvious. And I think the reason why we are now all on this sort of level playing field is because a lot of institutions have, from different angles for their particular clientele, prepared checklists or guidelines that were apt for this particular region in a language and also addressing issues that probably are not the same everywhere. You know, the technological issue might be a different one in the north of Europe than it probably is in the southern and eastern European parts, where you have probably other issues. And I think that was one of the reasons. And we really got a lot of response also from users, and said, thank you that also the VIAC issued a protocol, because now we also feel that you consider this a good idea. I think parties and arbitrators, they really wanted to have assurance also from their institution when they go about having a hearing, that they can follow a checklist. And at least, and I think that touches upon one of the questions, objections a party could raise. I think if the parties and the arbitrators, they follow this checklist, pretty much they are taking away most of the objections that could later on come, because they have taken care of all the issues. Is the legal framework at the place of arbitration okay? What is the access? Will there be a trial? What platform do we use? Is the access basically the same for all the parties? Because these are the usual things. Also the witness tampering that I was referring to before. So we really tried to compile all the experiences that we had made. And the Supreme Court decision, the Austrian one that we were referring to before, stemmed of one of the VIAC cases. So we also had seen, the objections of parties, the deliberations that the tribunal has had within itself, and we also wanted to give that to the community and really, tell people, listen, these are issues you really need to be aware of, and you need to take basically care of. Yes, that would be it from my side.
Actually, then that allows me quite neatly to pass the baton to Ndanga, because so you were talking about the perception and the needs of your primary regions, but obviously the pandemic was global and affected different markets. And so what I'd be interested in hearing from Ndanga is, what was the view from the African continent about remote hearings generally, and which, if any, concerns should we be taking heed of more generally, not just that issues that are there, but that are relevant to everyone. And maybe to put this in context, there was, I know some of this was already discussed at the GAR Interactive Africa, which you chaired, in December 2020. And so maybe you'd also be willing to share some of the takeaways from that from that event, which I'd say actually was the first ever and very successful GAR Africa event.
Thank you very much, Hafez. And in that case, look out for GAR Live Africa, which should be on African soil, hopefully later this year. But to answer your question, I think that this is still an unfolding story. And I think in terms of the responses or reactions to remote hearings in the African context, I think we see that across the world, that sometimes our expectations of how parties will respond, and by parties I mean all participants, arbitrators, counsel, and the clients themselves, will respond to remote hearings varies from jurisdiction to jurisdiction, and there's no kind of fixed response in each jurisdiction. Sometimes we see surprising results. But in the African context, perhaps I can highlight two things. And the first is that we see an expectation or a hope for inclusiveness, in that we see that this move towards a more remote working in international arbitration will allow more participation by African counsel, African arbitrators, which will bring them into the fold of international arbitration. Right, so there's a recognition that, hang on, we no longer have to worry about visas, we no longer have to worry about flights, we can participate almost as if you're in person by using this remote medium. But simultaneously, there's also a recognition of the limits of technology. So we see that across the continent, there are problems with the high cost of data. We see problems with connectivity. We also see just people who are entrenched in their practice of using paper. We still have colleagues across the continent who file requests for arbitration in hard copy and only use emails for some correspondence, but everything is done in hard copy. So that's still a challenge. So we're seeing a hope, a promise, at the same time an understanding of the limitations of technology, or moving towards a technological context. Now, in terms of what we should heed, I think on the first point, on the potential for inclusiveness, we need to recognize that there's nothing automatic about inclusiveness. And that technology can facilitate it, but it's not in itself going to suddenly turn international arbitration into an inclusive, diverse profession or community. And I think that that holds not just in the African context, but also when we talk about other diversities. When we're talking about, oh, now we'll see younger practitioners, or now we'll see more women, now we'll see people from different geographical areas, that's not automatic, but it is possible. So what this time has shown us is that if we think about working differently, and this goes to the slow that we've been talking about, if we allow ourselves to sort of step back and say, okay, hang on, what have we learned in this 1 year period, or a little bit longer, a little bit shorter, depending on when the pandemic really hit different jurisdictions? What have we learned about the way that we've been working and the way that we could work that will allow us to meet our goals on diversity, on inclusiveness? And if we take the time to do that, I think we'll see that technology does offer us the opportunity to allow more into the fold, more people into the fold. So that's the first point on inclusiveness. So it's not automatic, but technology does provide us a tool to make that happen, but we have to be committed to it in order to make it happen. Now, on the second point on technology, that's perhaps a bigger challenge in the African context, because we're not overnight going to get superconnectivity between different jurisdictions, or to get stable internet connections, or indeed to get stable electricity connections, because sometimes the challenge is that basic, that the lights go off and your modem is off, and that's that. But what it does do is that it reminds us that sometimes in moments of need like this, that innovation happens, right? So in the African context, you have seen a lot of talk about the use of mobile technology, and the use of mobile technology for banking and for all sorts of things, which the rest of the world is only catching up to now. That wasn't born out of nothing. It was born out of really necessity. So there was a realization that unless there was sort of this leapfrogging and moving from use of landlines and so forth to the use of mobile technology, we were always going to be left behind. So if we use similar thinking in this context, and I don't know what the answers are because that's not how my mind works necessarily, but I can see the potential for using this time to think, okay, so we have a problem with connectivity. We see that technology can allow us to have more inclusiveness, and not just in international arbitration. I think we think about it in dispute resolution more broadly. You know, getting to more remote regions in Africa and getting really access to dispute resolution across the continent. So we ask ourselves, what is it that we can do to bridge this technological gap? And that will involve governments, that will involve lawyers, that will involve policymakers, banks and funders and all sorts of stakeholders. But that's where I see really a parallel opportunity in addition to our own world where we're thinking about appointments and as counsel and as arbitrators. I see this other potential for real transformation, frankly, that can arise out of this period. And I hope that sort of answers your question in a sort of rumbly way, but I hope you got my points.
And a lot more, thank you. Maxi, I see you've turned your mic on. Would you like to comment?
I don't know if we have time, just very briefly. I think Ndanga has reminded us of a very important thing, and that is going forward now, we have remote hearings in the toolbox, but certainly it's not a one size fits all. It's certainly not a solution that helps, fits, suits everyone. And I think it is important that going forward, we recognize that. It was an emergency solution and still is, unfortunately, in the pandemic. But in a post-pandemic world, it is in the toolbox, but it's only one tool. And it might not be the best tool for a particular case. This being said, one of my probably most complicated remote hearings that was the longest, that included witness conferencing, expert conferencing, was bilingual with simultaneous interpretation. So had all the challenges that one doesn't necessarily want to have in a remote hearing, was actually between two African parties, involving witnesses in different African jurisdictions. So it is also testament to what Ndanga has just reminded us, that it is not necessarily as we might perceive it. There is a lot of potential everywhere in the world, but we do just need to be mindful of that. It might just as well also be a power cut, which actually happened in another case that I was involved, which was from a different part of the world. So maybe my last comment on this is really the most important is test and prepare every single remote hearing multiple times. I see now that there is always now sort of like the frequent flyer, blaseness about things. People have done remote hearings, they say, yeah, I'm fine with it. No, every single remote hearing is different, and you need to test the setup every single time, multiple times, and prepare it very carefully, because every time the setup is different. So I think that for me is really the most important takeaway for the future.
Many thoughts coming out of that, and I'm really enjoying this discussion, but I'd like to go to Annette, because I know you're chairing the forthcoming GAR Interactive on Women in Arbitration, and part of what the discussion will cover is diversity strategies. And I'm very curious, having listened to what Ndanga was saying, is to, do those strategies need to be rethought, adapted in our new online context, and bearing in mind remote hearings? And I appreciate this is to some extent a preview of that event, but if you don't mind sharing a few thoughts, those would be welcome.
Sure, thank you. I think Ndanga summed it up very well by saying it's not automatic with greater diversity, but it's possible thanks to sort of the new virtual tools. And I think that's, or the new virtual setting, if you like. And I do think that's really very worth thinking of, because it doesn't matter what kind of tools we have to our help if our minds up here don't change, right? So it really will start there, regardless of anything else. That's where it needs to start in any kind of shift in society, diversity, of course, being an important one. So I think that's really, really something to keep in mind. But it is true that the barriers will be lower in this context, and it will be easier for, again, as was pointed out by Ndanga so well, in terms of a great variation of people actually being involved in different areas of the international arbitration world than otherwise would have been possible, because the barriers are lower. The threshold to get in there, to be participant, to have your voice heard is actually much lower. So that's a great potential for diversity. But again, it doesn't come automatic unless we think actively about it, if we want to sort of include, not least, for example, more women when it comes to being visible at events and so forth. We will talk a little bit about this at the GAR Interactive Women in Arbitration next week. So there will actually be a discussion on sort of diversity in terms of building your career as an arbitrator, as we did in London when we had the first GAR Live Women in Arbitration not last year, 2019, December 2019, but that was the first one. So we will continue that conversation. And obviously that was we met physically, but I have great hopes that we will continue to have a very inspiring conversation also in a digital setting next week. If I can say something about sort of the things that have been said before, also about connectivity and the different challenges that could entail, and the expectations we might have on different areas in the world being more or less connected and or sophisticated. I do think one thing that we should also keep in mind in that conversation, just to throw in another element that we could worry about, is that, so connectivity is one thing, right? To not have your power cuts and to have a stable connection for hearing the full argument and what have you. Another thing that we should add is cybersecurity, right? So just having that connection, but then asking yourself, how secure is this connection? How secure is this virtual room we're now working in? And I do think that needs to be part of the conversation just as much as the stability or any other aspect of the connectivity as such. And we have seen, and it is becoming more and more important, that really needs to be embedded in any kind of step towards a virtual working environment. The security issue really needs to be at the forefront of that. So I just wanted to add that.
Thank you. Subject to any further comments on that, I'd like to come back now to the advocacy conversation we started having earlier, but I'm in your hands as to whether there were any further comments on what's been said. Actually, one comment on diversity, just to put a thought out there, in case anyone wants to react to this. A colleague of mine, and I think most or all of you will know him, Thomas Granier, had this interesting comment about one of the differences between physical hearings and remote hearings. In a physical hearing, you see everybody in the room, even if they're not talking. In a remote hearing, you usually or frequently only see the people whose videos are on. And to the extent part of promoting diversity is seeing the diversity in the community, remote hearings may actually be counterproductive at times, except if, as Maxi was saying, you can lay people out in a room as if you were in a physical room. But food for thought, in case any of you want to comment on that. Otherwise, on advocacy, I was thinking about what Maxi was saying earlier about the different way in which she'd run the case in terms of a series of mini hearings, breaking up the hearing. And I was thinking, what does that, what takeaway should counsel be considering from the fact of making the most of the flexibility of arbitration, as it were, not just in terms of how they plead at the hearing, but how they think about the advocacy throughout the case in general. Is that something you'd like to comment on?
Well, I'm not sure I'm the best person to sort of comment on advocacy from the council side, but let me maybe say that at the end of the day, what we praise arbitration for is that it can be tailored to the specific needs of the dispute. And that is sort of from an overall perspective, that's what we sell to our users, saying, you get the best possible sort of tailor-made procedure to what you need. But you can also, of course, sort of say that from a strategic point of view, from a council point of view, that you can think think outside the box and ask for a preliminary determination of an issue very early on if you think that strategically suits your case strategy. It's certainly more difficult for the other side now to say, oh no, this is going to be very complicated to have a hearing, because it's not. So these are, I think it gives more flexibility for strategic creativity on the council side, and it gives more flexibility from the tribunal side to try to tailor the case management to the specific needs of both parties and the dispute as much as possible. Now, on the advocacy, again, I've not been in front of a camera trying to cross-examine a witness or trying to plead in front of an arbitral tribunal. I have only seen this on the other side. And as a decision maker, and I think Hafez, this comes very well across in your Delos survey, from the tribunal's point of view, you don't get the impression that you have less takeaways, that you don't get to ask as many questions. You don't have the impression that you're missing out somehow on information that you should be getting in the hearing. And at the end of the day, isn't that the most important, even for advocates, that you get an informed tribunal so that they can make a decision? So of course, I am mindful of the fact that cross-examining a witness or pleading in front of a camera might not feel the same, and it might be difficult. But at the end of the day, it is convincing the arbitral tribunal and provide the arbitral tribunal with the information so that they can decide in an informed manner. So my sense to a certain extent is that remote hearings cut through a little bit of unnecessary advocacy. The French would call it effet de manche, if you just sort of fluff around a little bit. And from a decision maker's point of view, these are probably the sort of advocacy things that you don't want to have. You want to get to the merits, to the substantive discussion, really, about the issues. So it's certainly a sentiment that is shared amongst arbitrators, I've heard, and I've discussed it with co-arbitrators in the past weeks.
If I may just build on what Maxi has said, I completely agree with that. And actually, on the first point, on the flexibility, I think what we find is that on one hand, we talk about the flexibility of arbitration as one of its merits, one of its advantages, but actually what we see in action is a lot of standardization. So we see that, regardless of which jurisdiction an international arbitration is being held, you pretty much will get the same sort of procedure and the same sort of sequence of activities throughout the proceedings. So this time, this slow time, if we call it that, will give us this opportunity, as Maxi says, and she's given us some good concrete examples of how counsel and arbitrators as well can be emboldened to really take arbitration back to its roots of flexibility, and where arbitrators may be hesitant to say yes to some requests, to really hack back to this idea of the flexibility and why this flexibility of arbitration exists, and accept some of these applications to do things a little bit differently, of course, having reflected on whether they're appropriate or not, but to really not stick to what we've always done and what we've always been doing, just because that's what we've always done. And just on the point of advocacy, I think the reality we see is that you have good and bad advocacy, whether it's remote or not. So some of the disadvantages that we hear about remote hearings and not being able to come across to the tribunal effectively may simply be questions of whether the advocates themselves have taken the time to go through their pleadings, to prioritize, to find the best way of conveying their point, and that lack, if we can call it that, will exist whether it's remote or whether it's in person. So it's really a question of getting really, avoiding this fluff that Max is talking about, getting to the point, making sure everything from your written pleadings to your oral pleadings are as succinct and direct as they can be. And virtual hearings have not come to take away something that was there or the other way around. It's really a responsibility that advocates must have to convey their client's case in the most effective way possible, live or remote.
In a sense, what I've been hearing from all of you is arbitration is there to help as a solution to resolve disputes. And if anything, what we've got right now, sort of slowing down and just looking at what's there, is an opportunity to be more effective going forward in getting to that end result. And maybe to play back some of what I'm hearing, and do correct if it's not a correct interpretation, but that in effect what we're saying is remote hearings, or not being bound by the physical constraint of all having to meet in one place at one time, may actually allow arbitrators to take ownership of a case much more effectively, to be able to do what they're there to do, which is to decide the issues in dispute.
I wanted to add something on that point. I think, especially in these challenging times, there is a real need for strong arbitral tribunals who are really up to the case, who are not afraid of taking decisions, but taking informed decisions. And I think the sort of laissez-faire arbitration, where the arbitral tribunal simply sits back and lets a hearing of a week just pass and then sort of deliberate, I think that's over basically. But you really need a tribunal that is hands-on, that is able to decide on the spot, for example, in a remote hearing, if there is a connectivity problem, do we proceed or do we not proceed? Do we make a pause? How are the safety measures? So you must be very much up on the case. And I think that is also going to be a shift on how we appoint arbitrators, who is being appointed, that we really want people who are hands-on, who we think have the capabilities of also reacting and taking decisions. And maybe they don't have to be the absolute techies, but at least they should be willing to engage and understand what is going on. And I think in that also the diversity will increase. We'll probably see more younger colleagues or colleagues from people from different parts of the world. So it will completely increase or also change the way we look at and what qualifications and what features do we look for a future arbitrator. I think that's also an important issue.
Yeah, I mean, I would certainly agree with that. And looking at this from an institutional perspective, we certainly put an emphasis on proactive arbitrators. I think it's a necessity, especially as we look to the future. I'd like to put a technology question to all of you. And that is the following. So we've now integrated remote hearings into our arbitration toolbox. And barring another pandemic, another crisis, and having the possibility of approaching new technological developments in a slightly more serene manner, what do you think are the next frontiers for arbitration? If anyone wants to.
I'll start, and then see. I wanted to say arbitration avatars, but maybe that's not this year, maybe the year after, who knows. I do think that we have a lot of very interesting developments in the world around us that also will influence the way we do things in international arbitration. And I think we are to some extent already seeing some of it. But I do think we need to keep our eye on and again be part of the conversation and involvement of the increasing use of big data when it comes to the decision making, or AI in arbitration, whichever way you want to label it. But the ability to process large amounts of data and draw conclusions from it in a new situation, I do think that sort of in and of itself is something that will be an increasing part of the decision making in international arbitration and any dispute resolution going forward. And how that happens and how we make sure that we do not build in prejudice is in that how that is being done, and that we sort of not build in big divides, or that we actually maintain equality of arms and the level playing field. That will be up to us, but I would really like to encourage everyone to be part of that conversation, because I think that will be a big important new frontier. And if I can just end by recommending everyone to read an SSC forecast by my colleague Lise Alm, who's really diving into this issue here at the SSC, where she published a forecast right before Christmas, sort of on the how we should reach the cruising speed, so to speak, of the development of international arbitration. Because I think it goes back to the title also of this seminar here today, or the bus, if you like. I really like that picture, Ndanga, you were painting, of how we are on this bus and going maybe too fast for comfort at times. So to find that, to understanding we are on this very fast-paced journey, but at the same time making sure that we maintain the underlying values. And again, I think here, the way big data and the way we are able to process large amounts of information in the decision making, that's a frontier the way I see it.
I totally agree. I think this would be a topic for a whole other seminar, really, on automated arbitration, AI, etc. I've written on this separately, so happy to share that article with anyone who would like to. Maybe two comments on my side. The first is, while we are on the bus, the drivers, being lawyers, are typically very conservative. So we need to factor that in. It is a very fast-moving world, but lawyers are, extremely conservative in the sense, not politically conservative, but conservative in terms of solutions. So while I totally share Annette's recommendation to get involved and share and sort of get into the debate, I also reckon that we still hear people saying, no, artificial intelligence will never, ever come and affect our profession. And I think that's, it's a forlorn debate, because it already does. The other comment, and maybe more sort of terre-à-terre, more simple point in relation to what we discussed in terms of remote hearing, what I suspect will happen over the next month is that we will see an incredible evolvement on the tools, the video conferencing tools that we do use. Because I mean, while what we use is perfectly fit for purpose, there is a real potential for fitting it more specifically to the needs of arbitration. For instance, to recreate the sense of being in a room together. I've seen it once, and it really is quite astonishing how it works. So these, I think, are fairly mundane things that will happen in the months to come.
What I would like to add here is that, we are all simply, debating about the cybersecurity issues, and we're putting it out there, but we have not yet seen any major attacks, and there will be cases in the future where this really will be an issue, where a hearing had been hacked, data is leaking, information was published, and then the question arises, who is to blame? Whose responsibilities is it? Is it then the platform? Is it the arbitrators who have selected it? So there's a whole sort of area around that we are sort of, that we have to think about, because it will happen and it will have massive effects. So do we have to face that if you have the possibilities to enter into Pentagon, you can enter anywhere, and we just have to live with this possibility and, just hope that it's not going to happen. And I think this is also going to be a very sort of interesting discussion. And what if information is out there? We have in investor state arbitration, we have the transparency rules, so there is the want of the community to get more information. Is that per se bad after all? So I think there will be a great change also in terms of confidentiality and all that.
If I can just quickly add, I completely agree with what my co-panelists have said. And I think that what we're going to see more of is on the artificial intelligence. And I know that when we talk about artificial intelligence, we immediately start thinking about robo-arbitrators and get sort of these images of arbitrators replacing, of robots replacing arbitrators and judges and so forth. But of course, the reality is that artificial intelligence is not like that, or it can be, but the kind that will be relevant to us is not like that. So what will be interesting to see in the coming months is the community becoming more familiar with what artificial intelligence actually can do and what it is actually already doing, so that we're not surprised in the way that we've been perhaps surprised about all these tools that are available for remote hearings. You know, I know that certainly in January 2020, I had no idea how Zoom worked, but you know, soon after that, everybody was super familiar with it. So I think it would be interesting to see the community taking an interest in learning what artificial intelligence can do, not just so that, you know, when there's an emergency that we can use it, but so that we can use it to enhance our work now, and perhaps fill in gaps that we have or don't even know that we have. So that's a challenge for us to kind of to step into that discomfort of artificial intelligence and familiarize ourselves with its potential.
Maybe on a lighter note, I'm sure many of you have seen pictures such as this one, such as those on the screen in the past. These are virtual augmented reality headsets. And we were talking earlier about the survey. Our final question asked whether people thought that this might be the future of hearings. 54% either didn't answer the question or didn't know what these were. But of those who did take a stand, a third thought this is our future. So with that, we've covered quite a lot of ground. Just to pick out on some of the things that have come out of this discussion, we've heard that the community was adaptant and resilient, that it came together as a community. And that's a very nice takeaway for 2020. There was knowledge sharing, but then looking ahead and sort of slowing down and looking ahead, part of both the positives and the questions that seem to arise are, to what extent is what we're doing simply replicating the offline online? To what extent is it sustainable? Questions around inclusiveness, and maybe to tack on to what Maxi was saying, not to get complacent. She notably mentioned that one hearing to the next, you got to prepare. You can't just say, I know it. The same way as you prepare the substance of your hearing. And if it's about preparation, I think that point about you can't be complacent and you need to keep questioning and keep thinking is going to be relevant in everything else that we're doing. And it's what comes out of what you're all saying as well, that we need to be thoughtful, continue being thoughtful about what we're doing and as we look to the future. Those were my concluding remarks. Maybe, obviously, if you have comments, and feel welcome. And otherwise, I was looking at the questions. I think we've answered all of those that were on point. But maybe you have further questions you'd like to raise, and otherwise I'll say a word of thanks.
The only question that I saw in the Q&A that you might want to answer, Hafez, is whether this will be available, the recording will be available. And I would also like to thank you for getting us organized so well. I'm sure everyone will agree this has been a very pleasant and thoughtful and inspiring discussion. Thank you, Hafez.
Thank you. And to your question, yes, the recording will be made available. Everybody who's registered will get an email informing them about when the video is live and where to find it. And so we look forward to seeing you offline. Thank you to my fantastic panelists. I really enjoyed the discussion. I really enjoyed seeing the exchange of ideas, and I look forward to seeing you again, hopefully offline at some point.
Goodbye.
Bye.
Goodbye, everyone.
Bye-bye. Thank you.